counsel for the state, whoever's taking this one on, go ahead, please.
Yes, Your
Once again, you know, you can do podium, you can do council table, whatever you want.
I am excited to try the podium today.
Okay,
My notes say to say good morning, but I will change that, Your Honor. Good afternoon. May it please the court, Matt Bush, for the state of Nevada. Find a good place for this. Your Honor, if it's okay with the court, I would like to go through the state's arguments and why it opposes this provision. However, I heard you earlier, the state heard you earlier with your inclination, so I will provide you an alternative middle ground at the conclusion of my argument that the state would offer the court to consider if it does not want to deny Meta's motion outright. Before I jump into that argument, Your Honor, I would like to first say that I've heard from Meta's counsel today speak a lot about burden and the burden that Meta has in regard to enacting this provision. I'd like to note that under the language that Meta's counsel in the court discussed, the first thing that would happen for Meta's material, if it were being disclosed to a potential expert by the state, is that the state would have to disclose that expert's information to Meta. Meta then may within 7 days object to disclosure, so it's automatically.
can I pause you for a second?
Yes, ma'am.
Because
Yes.
you're saying the information. I'm hearing from Meta, the only thing that gets disclosed is John Doe and John Doe's CV.
Correct, Your Honor.
So how are you using the term information? Are you talking
The
about the
information
underlying documents?
related to the expert, but they're the expert's name, city and state of residence, and CV, website, or current employer.
Okay.
I apologize. Thank you for
I
correcting.
just want to make sure we're on the same.
No,
Go ahead.
please interrupt me as much as you need to. I am from the South and I get rolling downhill and my accent comes out. So please, to the extent that the court would like me to repeat myself, I'll be happy to do so. So after the state has disclosed this expert's information that we just discussed to Meta, it can choose to object within 7 days. The state cannot, during those 7 days, disclose Meta's highly confidential information to this expert. Then, if Meta does object within those 7 days, the parties must meet and confer. That's another requirement that the court discussed with Meta. During the meet and confer process, Meta has the opportunity within 14 days file a protective order that would require motions practice. All the while, the state has been unable to share with its expert that it has retained Meta's highly confidential information. And it is only when Meta files the protective order that it actually bears any burden at all. And that particular burden, Your Honor, is the burden of proving that the risk of harm that the disclosure would entail outweighs the opposing party's need to disclose the protected material to its expert. That's from the page 17 of the protective order, or sorry, page 13 of the protective order, page 17 of Meta's appendix, the contested provision, Your Honor. So there is a lot of stuff that happens here before Meta bears the burden for anything. And that is inequitable to the state for reasons I will discuss. That's just something I wanted to start with, Your Honor. Final thing in the starting is that it is Meta's burden under NRCP 26C to prove that the highly confidential designation of materials is appropriate. Meta has talked about it is a blanket approach to all highly confidential materials that this provision would apply. Meta has admitted previously that it has over-designated highly confidential materials and is now, to its benefit, de-designating those materials. But the fact that it is de-designating materials across jurisdictions means that it has at least first over-designated. So,
You're
yes,
saying they have acknowledged in the state of Nevada that they have,
in other litigations, Your Honor.
Okay, because
I apologize.
you all haven't, other than jurisdictional discovery, I wasn't.
There
really
is
sure.
no
Okay,
correct, Your
okay.
Honor.
I mean, maybe you have and nobody told me, but it didn't seem like you had. Okay, go ahead.
No, not in this not in this jurisdiction, Your Honor. In negotiating the protective order, which I'll get to in a moment, part of the provisions that we've discussed is that those documents that Meta has produced in other jurisdictions will be produced here in Nevada once the protective order is in place. And those documents that were produced over designated in other jurisdictions and then de-designated, Meta would produce to the state the de-designated version of that document. So there has been over designation. So we are talking about a significant number of documents. Counsel for Meta mentioned that the productions Meta has made in these other jurisdictions is in the millions. I'm not sure what percentage of documents
Millions of pages or
millions
millions
of
of
documents
bytes?
is my
or million-
understanding.
Okay,
And not that the majority of those are highly confidential. In fact, I believe Counsel for Meta said that most of them are just confidential, but still even a 10% of those millions is a ton of documents here in Nevada, Your Honor, that would trigger this provision. Those are my beginning pieces, Your Honor. I'll go through as briefly as I can the state's arguments, and again, feel free to stop me at any point. And then as I promised, we'll give the state a middle ground. I believe that would be much more fair to both parties, and this provision would be against the state. By way of background, Your Honor, the parties have been negotiating this protective order since spring of 2024 during jurisdictional discovery. It's taken quite a bit of negotiations between the parties, but we have reached a point where we agree on everything in this proposed protective order, but for this one provision, paragraph 36. The purposes of this provision, Your Honor, is to disclose experts earlier than would be normally appropriate than would normally happen under Nevada law. I will not go through the exact language because the court and Meta's counsel, I think, went through that exactly as it is written. So directly into our arguments, Your Honor, the state has two major sources of issue here. The first being the provision is inequitable and one-sided in that it's in its practical use under the party's actual circumstances. So Your Honor, or the court mentioned earlier, conceptually it reads well, and I agree that it does because it puts burdens on both parties. It does not say one party versus the other. Even if Meta chooses to use its own material and share its own material with its experts, it would still have to disclose that expert to the state. It reads well, Your Honor, but practically it is actually very prejudicial against the state for these reasons. Meta is the only party in this litigation that is going to produce documents and designate them as highly confidential, or designate non-party documents as highly confidential. The state intends to do neither. For reasons laid out in our briefing, just the state is not in custody or control of any such documents. Excuse me. Therefore,
I'm going to stop you because you mentioned non-party documents. Can you point to me where in the protective order it said the highly confidential designation can be placed on documents that are not one of the party's documents?
I can attempt to, Your Honor. I reference Meta's reply. I believe that they said it applies to non-party documents as well. I think it is not in this particular provision, Your Honor, but elsewhere in the protective order where it says the parties can designate third party or non-party documents as
Page 15, non-parties protected materials, this litigation, but how does a party determine that a third party's material is highly confidential?
I believe, Your Honor, this comes from the meet and conference that we had where there were subpoenas that were put out to potentially consultants of Meta, Your Honor, that would have documents that they worked on behalf of Meta that they would want to designate as highly confidential, that would have their trade secrets, their code, their algorithms. I apologize, Your Honor, I'm not going to be able to direct this court direct to that statement, so I will recall it and happy to move on in my argument as I don't want to bog the court down.
No, I do need to address the non-party concept. Okay, so from your position, you're talking about subpoenas in other states, correct? You're not talking here in Nevada yet.
It would be once they were to happen, Your Honor.
That's where I'm going, but our Rule 45 process, right? If they're sending a subpoena, the third party has the right first to object, and the parties have a right to object under NRCP 45. Remember, I'm a Nevada judge, okay?
Yes, Your Honor.
I have practiced in many places, but I'm a Nevada judge, so I have to focus on Nevada law. And so how does this come up? Your consultant issue, it would have to be a 45 subpoena, right? Which has certain provisions and certain objections before the information is actually even produced. Are you saying that is there an agreement between the parties that third party information is going to be produced either through 16.1 disclosures or pursuant to discovery that's going to include non-party information? I mean, once again, I'm focusing it on how this works out in practice, right? Hypotheticals are fantastic, but I need to look at.
That's perfectly fair, Your Honor, and I appreciate you stopping me and bringing this up because I believe I may have spoken out of turn.
Mhm.
I found the page that I was referencing in the in Meta's reply, and it states that it applies to all parties, not just the state. And I believe in my preparation, I included non-parties in that as well. So if I may, I will retract that final statement.
Well, wait a sec. I mean,
Okay.
do you have the protective orders that was attached?
I do, Your Honor.
Page 15, which is date stamp 19, paragraph 40. That's what I thought you might be talking about.
If you'll permit me just
Yeah,
a
of
moment
course,
to read
no, of
this, Your Honor.
course.
Thank you.
Roman numeral 9.
I'm there, Your Honor.
Okay. Information produced, there it does say information produced by a non-party and designated as highly confidential. This one. But since this had the other protections, I thought that was a reference to 45, that you would have a, although it doesn't cite 45.
In reading this provision, Your Honor, I do, and you talk about hypotheticals, I see the way in which I described where a subpoena from someone that has worked with Meta and somehow has control or custody or control over a document that would contain Meta's trade secrets, proprietary code or such. If the state were to subpoena them, for instance, Meta would want to make sure that it has the opportunity to designate those materials as highly confidential. Such that they would be documents that Meta would typically have the control of. They have Meta's own information in there, but in this case, that they're in the custody control of a third party, of a non-party, Your Honor. And I do not see any distinction in this protective order in terms of the contested provision in 36, it being only, it applying only to Meta's produced material, but also to any produced material that a party may designate as highly confidential.
Can I get the simple one sentence answer from whether or not it is the intention that this covers documents? When I'm using the term documents, I'm including electronic and hard copy, right? So provided by any third parties, or is it purely Meta's and the state of Nevada's?
There is the possibility that a third party who is a consultant for Meta or works for Meta in some capacity would have access to and would have highly confidential documents or information in their possession. If they were subpoenaed, there is a process by which Meta would be able to challenge the production of such or establish the confidentiality around those documents.
But is your proposal intended to add an additional level? Meaning, usually if you waive a 45, you waive to 45, right? So, and if I need to pause for a second, you need to consult with local counsel, not in any way saying that you don't fully know Nevada law. I'm just giving the benefit if you need it. Means if you waived it, you waived it. So is this saying, even if you waived to 45, then after the fact, you can stamp something that you never objected to as it coming in initially, that you can then mark it highly confidential and then it's covered by this and has to go to the expert aspect? Is that the intention? If you need a moment, feel free.
I do
Yeah,
need a
yeah,
moment.
no worries,
Just
no
to
worries.
make sure.
Objection to the 45 would still simply lets them get the information.
I'm appreciative. I've got people, got a lot of you pro hocs, so.
No, I appreciate
And if you
appreciate you
need to
stopping me,
consult-
Your Honor. We need to sort all of this out. We've been negotiating for a long time, so it's good to go for a resolution.
Your Honor, as I understand it, there is a separate process under Rule 45 that you were describing. Our ability to challenge the production or the subpoena that seeks the production of materials that we could or could not invoke at certain points. There's a separate, that's a separate process to what we've put forward here, which is if a non-party has confidential or highly confidential documents, there's a process by which that could be challenged. And the provisions from section 40 to 43, I think, lay out the challenging of the designation of confidential or highly confidential, a process for doing that in the litigation.
Right, so the court's specific question, and part of the reason this goes back to, right, in 45, party objections. A party receives notice under 45A4, another party intends to serve subpoena juris tecum on a third party that will require disclosure of privilege, confidential or other protected matter to which no exception or waiver applies, may object to the subpoena by filing and serving written objections to the subpoena and a motion for protective order. To invoke the protections of this rule, the objecting party must file and serve written objections to the subpoena and a motion for protective order under Rule 26C within 7 days after being serviced with a notice and a copy of the subpoena under Rule 45A4A. Little 3. If in the objections in motion, the party must specifically state the party's objections to each command to produce documents, electronically stored information, or tangible things, or to permit the inspection of premises, and demonstrate a basis for asserting that the command will require disclosure of privileged, confidential, or other protected matter, and establish that no exception or waiver applies, and that the objecting party is entitled to assert the claim of privilege or other protection against disclosure. Little 4. If the party objects based on privilege, confidentiality, or other protection and timely files and serves objections, and a motion for protective order, the subpoena may not be served unless revised to eliminate the objected to commands until the court that issued the subpoena has ruled on the objections of that motion. Sublittle V, the objections in motion practice are subject to provisions Rule 26C, G, and 37A5. Those are pre-protections when you're first trying to seek third-party information, right? But it has a specificity requirement leading to, you can now appreciate a lot of my questions about specificity, because we're used to seeing in things, there are specificity of what you're actually saying can't go over. It's not a general million documents, 10,000 documents or something like that, right? It's a specificity aspect. So my question was, A, does it cover non-party documents, or are you just relying on 45? If it's intended to cover non-party documents, your consultant example, does that mean even if a court rules on 45, a document gets produced, you can still stamp it highly confidential? Now it goes through this process as well? And what does that do for a court order that's already said that you haven't met the standards under 45? You know what I mean? I'm trying to reconcile some of our specific rules with what you're requesting.
I think yes is the answer to your first question. It does apply by its terms to non-party. And I think that the process that's laid out here to non-party documents in the way that we've described, and I think the process that's laid out here, it says any party issuing a subpoena to a non-party shall enclose a copy of this order, an indication that this procedure would occur at the same time.
Instead of 45? So that means you don't have to have the specificity aspect of 45?
Well,
You don't have to say it's privileged, or is it in addition to? You understand?
I think this
Mechanics.
requires the specificity that you're describing in Rule 45 in this respect.
It doesn't. 45 requires, if you're saying document 56 shouldn't be provided, right? Document 45 shouldn't be provided. You need to articulate 45 shouldn't be provided because of blank. 56 shouldn't be provided because of blank. You can't just say any document marked highly confidential shouldn't be provided.
Right, but this provision is not saying that. This provision is a different provision than the provision about the expert disclosure. This provision says you have to have the relevant discovery request.
Okay, you got to tell me what page you're referencing when you're saying this provision, please.
So the provisions at paragraphs 40 to 43 are different from the expert disclosure provision in that.
But do they reply to the expert disclosures? That's really where I'm going, because the issue before the court today, right, is purely on expert disclosures. So does 40, etc., apply to the expert issue? John Doe, the expert, wants to see Jane Consultant's documents that were gotten or received pursuant to a subpoena after a court after people already had their 45 rights. Can Meta, in this example, because I'll make it your consultant, right? Your consultant, right, provided these documents. Can Meta then stamp those documents as highly confidential, and therefore then the state would have to do a second processes? Or does 45 handle non-parties, and the only thing that happens with regards to experts is the parties' documents? That was where we're going back to my initial question.
I think that the way this would happen is that the subpoena would have to take place, and the process about the subpoena and the documents would happen. And if we wanted to mark those as confidential or highly confidential, that would happen as part of the procedure that's written here, with specific information identified and specific documents identified. And once that process is complete, then we'd be in a situation where either the court has said it is highly confidential, you have protections, or it's not, and they can use it in a more free fashion. And then the question of expert notification and expert disclosure of this document would take place. I think that
I don't think you were clear. Okay, let's walk through process, okay? Are you in any way modifying NRCP 45?
no,
The intention?
no,
Okay, so a subpoena is sent to consultant Jane, okay? Two types of scenarios. Scenario one, no one objects, Jane produces 15 pages of documents to make my life easy, okay? Are you saying Meta can then stamp any of those 15 documents highly confidential, and then the state, if they wanted to provide those 15 pages or any of those 15 pages to their own expert, they would then need to go through this process as well, even though under our rules, you will have already waived it because of the Rule 45 concept, potentially. I'm not making a ruling, I'm just, okay, but conceptually, because you haven't objected at the front end for those documents being provided, right? And you would have to have objected if you felt they were confidential or privileged under the straight language of 45. So my simple question without, I'm not making any rulings, I'm just saying, are you saying that Meta could do that? Could they stamp, in my hypothetical, Jane's 15 pages, which have been produced, right, without any objection by Meta, mark those highly confidential, and then the state has to go through the process of highly confidential?
yes, I think that is right. And I think that Rule 45 is about a disclosure to a party in the litigation, and it's not about a disclosure to expert witnesses or third parties. But I think that, yes, in the scenario you described, Meta would be able to assert that it's highly confidential, and the state could respond with whatever arguments they might have about the fact that it's not, or that they could take a position that there's been waiver. But no, I do not think there would be waiver in that scenario where we're asserting protections under the protective order. And I don't think that scenario should occur, in part because the state is obligated to share their subpoena at the time they're going to send it to a non-party. And so at that, well, any party.
But see, that's where my question really lies. You had a chance under Rule 45, if you felt something was confidential, to object to it before it actually comes to the state. And so it appears you're trying to add a second layer of requirements, which may be inconsistent with the court ruling, right? Or the fact that you didn't object at the front end, and now you get a second bite, which raises also a timeliness issue. I'm just, like I said, the concept sounds good, but I've got to have an understanding, because we don't want an unintended consequence that you get a double process, unless the state's okay with it. I mean, I don't.
The goal is not to create a double process. I think there are processes for different things, but let me.
But how are they?
Could.
Okay, I got 4 people wanting to stand and answer this. So let the state hasn't had a chance. Let me let the state finish their argument, and you can address this in response, and gives you a chance to chat among yourselves.
I was just gonna say, we just like a moment to confer if we could do that.
I figured you might. That's why I was saying I'm gonna let the state finish, because we kind of got off on this tail end as soon as council, you said non-parties, and I'm like, wait a second, there's a whole process we have. And I just, go ahead. Finish up
Thank you, Your Honor, and appreciate you, stopping me there, else I would have, walked right past it. So, it's always good to flesh it out. I agree. Before I get back to my argument, based on this long pause, this long discussion, I'd like to point out again that it is the Meta's burden under NRCP 26 to prove up the highly confidential designation, and prove that it is appropriate. There's another issue here with bringing in the non-party documents, and applying those to the this expert shielding early disclosure language based on just this blanket approach to highly confidential documents and not particularized documents, Your Honor. I'm getting into future argument, but there's Meta is effectively asking you to make a ruling here in a vacuum without looking at any particular highly confidential documents and determining whether there would actually be any prejudice. I will shoot back to where I was, Your Honor. As I was saying, Meta is the only party that will produce and designate highly confidential material in this matter. The state will not, just because of the types of documents the state has custody and control of. As such, it's Meta's documents, Meta's highly confidential documents that would be the trigger or the disclosure of those documents that would be the trigger for this provision. Therefore, Meta is the only party, Your Honor, that can, in good faith, object to the disclosure of such material to experts. The state does not produce these materials and does not see a basis for objecting to Meta designating, does not see a good faith basis for objecting to Meta sharing its own highly confidential material with its own experts. So it is in effect a unilateral tool that Meta can use against the state to derail its expert work, Your Honor. As I discussed, there's quite a bit of steps that go through before Meta needs to show any burden. And that stops the state from being able to share with its experts this highly confidential material until we have reached that natural resolution. And it can do so, Your Honor, whereas the state cannot. Additionally, under the language in this provision, Your Honor, it encourages Meta to over-designate documents in this litigation, or at least it makes it to where when Meta does over-designate a document, whether intentional or not, of course not claiming that would be intentional, easier and safer on first pass for sure, it would then create this additional hurdle the state would have to jump through in order to make use of its experts and let its experts opine. Excuse me, Your Honor. Meta could also object to an expert every single time the state sent this disclosure over. There is no language in here that states the reason for that Meta must object to an expert, the reasoning that Meta had to object to an expert. It would be fine within this language, Your Honor, to for the state to disclose an expert, their information, the information that we talked about, Your Honor, to Meta, and then within 7 days, Meta file an objection, send an object generally speaking, and say that it just needs more time to determine whether there will be some risk. And that objection automatically creates a meet and confer requirement, Your Honor, and then puts us on a path towards a potential protective order. Meta can do this as many times as it wants to every witness, every expert that the state brings up. And again, it's a unilateral tool that creates prejudice against the state. Moving on, Your Honor. I stayed on that one for longer than I intended. I apologize. The parties' needs differ regarding expert assistance in this matter, Your Honor. The state needs to retain experts as soon as possible to formulate expert opinions, Your Honor, to help the state in its litigation efforts. Meta, on the other hand, is differently situated. Meta does not require to retain consulting experts right now to just begin to understand the complex materials that Meta has, the materials that the state has not even seen, Your Honor. Instead, Meta can rely on its own employees. These are presumably very highly paid employees of one of the largest tech companies in the world. And to use Meta's own words in the reply, and I've just put it away, Your Honor, but I can reference it if you like, it is one of the most competitive and lucrative industries. That's how Meta describes itself. So its employees, Your Honor, have specialized knowledge. They are already under the employ of Meta, and therefore would not Meta sharing with them confidential, or excuse me, material that is marked highly confidential would not trigger this provision, Your Honor. Meta is able to therefore sidestep triggering this provision to the state. And again, I come back to it. It is a unilateral tool for Meta just to use against the state. The state will not, under any facts that I can reasonably determine, object to Meta showing its own highly confidential material, because the state will have none, to its own experts. There just would not be a good basis for objection there, Your Honor. So the only time it will ever be used is by Meta. Again, going back to on its face, it looks, I believe the phrase Your Honor used was conceptually it reads well, but practically it is unilateral and prejudicial against the state. I'll move into my second argument, Your Honor, and that is that this provision is a departure from Nevada law. First off, I've said it several times, Meta's burden under 26C is to prove that highly confidential designation is appropriate. Its burden under 26C is also to prove that this provision, this contested provision, is an appropriate provision to be entered in this action for good cause. That's NRCP 26C and Venetian, Your Honor. Here, this is speculative harm that Meta is referencing. Speculative harm that if expert retained by the state were to breach an agreement, we'll get to that, and somehow disclosed Meta's highly confidential material that it would create economic harm to Meta, loss of its trade secrets, loss of its proprietary code, etc. That is all speculative harm, and speculative harm should not be considered good cause under Nevada law. Additionally, Your Honor, it creates a couple of brand new opportunities for Meta to interfere with the state's litigation. First, and we discussed this during the JCCR, I'm sorry, the 16.1 conference we had earlier about the JCCR. NRCP 16.1A2E, I had to look at that to get it correct, deals with the timeliness for disclosure of experts. Also in that provision, or one right there at it, the parties can agree to change that, or the court can order different, right? So based on our discussion in 16.1, I believe that we did agree to different disclosure of initial experts. And it's not in front of me, but I'll believe that may have been June 30th or thereabouts, or I think that's right. Regardless, Your Honor, the point stands that enaction of this provision would mean that the state would have to disclose its experts earlier than that agreed upon time, or court ordered time, or had the court stayed with the requirements under 16.1A2E, those timing disclosures.
Practical question.
Yes, Your Honor.
43 cases, right? 34 in MDL or somewhere, numbers around there, right?
Numbers, I think it's 34 in the NDL and a couple of others at state court, Your Honor.
So if are you not going to be using some of the same excerpts that are being used around the country that they're already subject to these provisions? I mean, in the real world, it's happened in other multi-state litigation that in essence, most of the same experts with some unique ones, because you want some Nevada law concepts, right? But potentially, but mostly the same experts show up.
I imagine that is the case, Your Honor. Here, I know.
That leads to that likely is the case.
Oh, I'm sorry. Likely in the case in the situations that you're describing, Your Honor, and I'm sure that and counsel, any other co-counsel can jump in and correct me if I'm wrong, but I do believe that we have been in discussions with having experts that have been involved in other litigation, but we certainly have our own experts that are not under any of these requirements because they are not experts in any other litigation currently, is my understanding of where we currently are, and we are still retaining experts. We're still in that process. We have not received a single document from Meta since, even in initial disclosures, since that jurisdictional discovery in 2024. So we are still working to get our
You were supposed to do it at the time of your JC's. I don't recall.
Meta refused to produce documents until there's protective order entered in this action.
Hold on a second. With what court authority, though? I mean, we're not going to segue there because that's a whole nother afternoon conversation. But I would be very careful about people not complying with the letter of the law, which has specific requirements and has specific provisions that can request from courts if there are requests not to comply with certain deadlines, which we're not going to discuss this particular moment. But I will tell you, I would be surprised if someone could take that position unless they can show me something with my signature on it. But we're not going to go there right now. We're going to, because if we get sidetracked, I got to deal with experts. I got to get this motion taken care of, folks. Okay. I just give you that friendly heads up that unless there's a stipulation and my signature's on something, okay, then that raises a strong issue under 16.1 obligations, like I said, because there's a process by which people can ask. We're not going there. I'm not going there, folks. Please don't
Just in
keep
one
talking.
sentence.
No.
Just to
and no.
clarify,
No, counsel is speaking.
That's fine.
Your Honor, just in case I misspoke, I would
You want to check with your co-counsel? Because
Your Honor, just to clarify,
no, he's speaking. We can clarify with him and he can say it, because if I'm not letting the other side, I mean, it's a non-issue. Well, we're not discussing it today anyway, because we're discussing experts, but
apologize, Your Honor. I confer with co-counsel. I may have been a bit too broad in my strokes, but they did not disclose insurance documents which were required under the initial disclosures. But we will not approach any more today. I apologize for going there with the court.
so your objections, okay, I really, let's try and hone people in to focusing on, okay? This court does have some concerns about mechanics, which I think my questions have made abundantly clear. conceptually, they are gonna get an order, okay, because they need to, because for all the reasons I said in my inclination, including specifically that you're gonna retain an expert that's gonna be under certain obligations in certain states, and you're not gonna have certain inconsistencies, but it is fair. I have strong concerns about the 45 issue for non-parties. You can't double dip, and somehow I have concerns about the specificity aspect, because I'm really having a concern on how a court can make a ruling, court or special master make a ruling by just saying, oh, we've labeled whatever number of highly confidentials as highly confidentials, okay? If it was 10 pages, maybe, but somehow it looks like it's gonna be in the thousands. Okay, or even if it's,
Imagine Your Honor, or higher.
okay, but I give that as a minimum threshold, which I thought was probably less than it probably is going to be, okay?
Yes,
Just
sir.
on the number of pages I get in a single pleading, right? Attached to a single pleading. That being said, we have to come to a work that is, makes it equally for the parties, because this court, they have the very practical and reasonable argument that they're highly confidential information, right? Their trade secrets can't get out, and they've got certain protections under Nevada law specifically there too, okay? The mechanism aspect does need to be worked out. It has to be done in an efficient, timely manner, okay? This court does not see that there's a concern about it's requiring you to disclose experts beforehand, because realistically, giving the name without giving all the information, I don't see that prejudices you, even if they're not experts that are already being used around the country or somewhere else in the country, because their information is going to come out, whether they know Jane Doe's name on May 30th versus June 30th. I don't see that anybody has shown how that is the least bit prejudicial. The aspect of that, it's more likely that the Meta is going to be objecting to your experts. Well, there's the safety factor, and that is that they're going to have to bring it before special master and then report and recommendations to this court. And if they're doing that on every expert, there's Rule 37. There's a whole bunch of mechanisms that are in effect, you know, that would minimize. I'm not in any way saying it would be abuse, but there's mechanisms to minimize any concept for abuse. The time periods, this short 7-day periods, and then filing their motions. Yes, whether or not this court is going to add something in, that it has to be articulated similar to the 45 argument, that even if the party is objecting, that they have to say which highly confidential, because I think that will streamline and allow whoever's making the determinations to know what they're talking about in order to make well-reasoned determinations, okay? Because nobody's told me that this process has already happened in another state and that there's something that's specifically done. But in Nevada, they're gonna have to be evaluated, right? And in order to establish a burden, they're gonna have to say, well, can't you say because it's highly confidential because we say so? They're gonna have to say it's highly confidential because these documents are trade secrets. This person works for company X, right? But if it's a medical one, it might not have the same impact as if it's somebody who is discussing technology related issues. I'm using that as a broad situation. Okay, that's not a ruling, but I'm just, you know, it's going to be expert specific, but anybody making rulings is going to have the tools. So sorry if I'm kind of jumping to where we need to go, but what's your midline other plan? And if you need a moment to consult with counsel, that's fine.
I appreciate it.
So I give everyone a 5-minute break so everyone can consult with different people, so that, does that make sense?
Your Honor, the state would
minutes.
appreciate that. This is an important issue, so we'd appreciate.
So we
a
should
few
give
minutes.
you, everyone a 10-minute break so everyone can consult with whoever. That way we don't have people
Your Honor.
worrying about whispering right in front. Okay. See you back at 3:10. Let's make sure. Okay, we're back on the record. The red light's on. Counsel for the state, go ahead, please.
Thank you, Your Honor. I did not expect to stand at the podium this long today, so appreciate you bearing with me as I work through this. We absolutely hear, Your Honor, that there needs to be a solution here. We want to present something for this court that the court can grant, that it feels is a middle ground. It is difficult to be able to describe exactly what that is, Your Honor, in the abstract without documents actually in front of the court for which it can make a determination of risk. So I will present this solution, the state's proposed solution to the court. If the court will allow a tiny bit of background as to why the state believes this will work. I'm going to spend a good deal of time talking, and Your Honor mentioned earlier that this provision exists in litigation across the country, including MDL. It does not exist in the state of Massachusetts. The Meta asserted the same language there. The state of Massachusetts litigated that, and the state court there struck this exact language, Your Honor. So to use Meta's words, the bell has been rung in Massachusetts. We attached the Massachusetts order as exhibits A and B, or 1 and 2, A and B, I believe. 1 and 2, I apologize. 1 and 2 to our opposition. And we would ask the court to take a similar approach to the resolution there, Your Honor, and that is that the state struck the proposed language here, paragraph 36, or at least struck the disclosure language, excuse me.
Okay, let's get 2 pages and Bates stamp numbers.
Yeah,
so
of
that
course,
everyone's
Your Honor.
literally on the same page, please.
So it'll be exhibit to the opposition, Your Honor. Exhibit 1. That is Bates stamp 001, shows the order of this entry, Your Honor, and I want to apologize in advance to the court. The Commonwealth, as said, state of Massachusetts about a dozen times as well.
Hold on a second. State of Nevada's opposition.
Yes, Your Honor.
Okay. Joint status report to Suffolk County. That's what we're referencing.
That is it, Your Honor, and
Okay, go ahead.
I
please.
have said the state of Massachusetts. I hope no one here is from Massachusetts. It is Commonwealth, so I will try to be better about that, Your Honor. This is a singular page showing that this order has been entered by the court. You'll notice the court's handwriting, Your Honor. I apologize that we don't have something similar to what the state of Nevada would produce, or Department 31 would produce after having entered this order. But this is all for Exhibit 1, Your Honor, and Exhibit 2 is the same protective order, Your Honor, that has been entered. It has the writings of the court. And I would refer this court, Your Honor, to this exhibit's own exhibit, and I will provide a page number. There, Your Honor. Oh, I permitted that. I apologize.
Yeah, if you just give me Bates numbers is the most helpful, so that everyone's got the same.
I understand, Your Honor. We're looking at page 16 of this exhibit 2. Bates number 16 of exhibit 2. Paragraph 36.
Okay,
Okay, so this is the same provision, Your Honor, that Meta has asked the court to enter in this litigation. Titled Procedures for Disclosure of Highly Confidential Protected Material to Experts. If the court will flip to the following page, Your Honor, page 17. Oh, well, I'm sorry, let's flip between 16 and 17. I'll read for the court's benefit. Before a party provides highly confidential protected material to an expert retained in connection with the prosecution or defense of this litigation, the party, both the designating and receiving party, just like in the current phrasing, Your Honor, both parties shall A, obtain from such expert a signed acknowledgement and agreement to be bound, which is Exhibit A, which the state has, or this is also Exhibit A to the protective order in the current instance, Your Honor. And B, importantly, this is where I draw the court's attention, obtain from such expert a written statement that such expert is not an officer, director, or employee of a party or of a competitor of a party, nor anticipated at the time of retention to become an officer, director, or employee of a party or of a competitor party. And C, Your Honor, obtain from such expert a written statement that he or she is not involved in competitive decision-making on behalf of the party or a competitor or the party. And the court has entered in the court's initials, in addition to that, consultant to or expert for a party or a competitor of a party. The court will note that insertion in both of those lines. Your Honor, so Meta has come forth and they say that they need extra protection here because of their trade secrets, their highly confidential information materials, Your Honor. And throughout his briefing papers and today, the harm that it is claimed is it will be incurred if individuals that is mentioned as competitors, so those that consult for competitors, those that work for competitors, potential employees of competitors, individuals that may work for a competitor in the future. That is what Meta is worried about. That is the disclosure that Meta claims will harm it. Trade secrets go into a competitor, Your Honor. Proprietary code being reviewed by an expert in one place and used on behalf of a competitor in the future. That is something that the Commonwealth of Massachusetts Court explicitly looked at here and made sure that by including this second document with what the state is calling an affidavit, Your Honor,
You're saying that the court has the benefit of a copy of that Exhibit A?
Exhibit A to the
Massachusetts.
I don't believe that it was attached to what we were able to pull from the
So
map.
how would the court know what they're actually signing off on?
That's absolutely fair, Your Honor. I would refer the court to the language therein that I read, where it's an expert, where the written statement is explained here in the wording, Your Honor.
Right, but-
Admittedly, not a perfect four corners of the document, but that is all that the state would
Sure.
require.
But the council, with the court's question, maybe I wasn't clear.
Yes, Your Honor.
Okay, it's got sub shall, right? And there's got little A's and B's and et cetera. See that? Okay, so when you got little A's and B's and C's, those are independent, right? You need to do whether they're 1, 2, 3s or ABCs, correct? So you see under A, obtain for the expert, a signed acknowledgement and agreement to be bound, paren, exhibit A, end of paren. What the court does not have the benefit of, that at least I saw, and if you think I do have it, please let me know.
I do, Your Honor, and I apologize. It's just, I wish that it was attached herein to this document, but it is the same acknowledgement agreement to be bound is actually attached to the protective order meta proposed in this action, Your Honor. So I would change,
How do I know that? That's what I'm saying, because when I was looking through this and I was looking through the Massachusetts one of the concerns is this says to be bound paren exhibit A, and then it says B, and then you talked about B in the language that was added. But the court didn't see that there was any exhibit A attached there to know what the expert was additionally already agreeing to.
okay, Your Honor, I see the court's point, and if there was an exhibit A that was the same as it is here, which I believe that it is, because this is Meta's protective order that they have been agreeing to and litigating in jurisdictions, it would be clear 1-to-1, Your Honor. But I believe if the court looks at exhibit A to Meta's proposed protective order entered in this litigation, it is entitled
There's no protective order entered in this litigation.
I'm sorry, to be entered. It is requested. Thank you, Your Honor. I get running downhill with that southern draw. I did tell you that, and I appreciate you calling me on it.
So what we're talking about is now go to exhibit 1, at page stamp number 4-31 to their motion. Is that what you're asking the court to do?
Yes, it is, Your Honor.
Okay, so which page in those 31 pages are you asking the court to look at, please?
Pages 30 and 31, exhibit A, Your Honor, acknowledgement and agreement to be bound.
So. And how would I have known that before I asked the question today? It's the same, because this is on Kemp Jones's letterhead.
Yes, Your Honor, I believe the co-counsel for the state mentioned some turnover. I'm sorry, that's not actually.
I'm fully familiar who the Kemp Jones firm is. Sorry. You stated that this is the same exhibit A that would have been attached to the Commonwealth of Massachusetts order. Is that correct?
That is the belief of counsel of the
Okay.
state, Your Honor.
So a reasonable person reading through all of these and preparing for the hearing, if I see something on Kemp Jones's stationery, how would I know that that's the exhibit A, the same as to the Massachusetts order?
Yes, Your Honor. I believe the answer to that lies in when I first stood up here, Your Honor, I told you that the parties have been negotiating since jurisdictional discovery. One of the earliest documents, and I believe this is in the declaration of Phil Carlton from the state's opposition. One of the earliest emails that we have from Meta is a copy of, and I believe it was the DC protective order that had been entered in that litigation, Your Honor. And my understanding is that Meta provided that document and it was in PDF, and that the state converted it to Word. And we have since been negotiating a protective order for the last 15 or 16 months.
I confirm that.
You
with
absolutely
better-
can, Your Honor. I would love to know
Let's
as well.
make sure. Like I said, there's no A attached to the Massachusetts order, so I had no idea what anybody's contending. There's no reference in
understand,
the
Your Honor.
pleadings that says it's the
And
same.
I would like to know personally if you would be so willing to ask it if this acknowledgement, this exhibit A for both is the same.
Meta isn't the same.
I'm not in a position to absolutely confirm that every single word in both of those acknowledgements and agreements to be bound is precisely the same for Massachusetts and the state. I believe so, but I would not certify that at this moment. I have not checked between the two documents.
Is it in essence the same?
Yes, Your Honor.
Go ahead.
Thank you, Your Honor, and thank you for clarifying. I apologize that was not provided in the papers that we were able to obtain from the Commonwealth of Massachusetts. So therein, Your Honor, the state's request would be that the state, when it retains an expert and intends to share with them non-confidential, confidential, highly confidential information, would have the expert sign this Exhibit A, acknowledgement agreement to be bound. That brings them under the jurisdiction of this court, and under penalty of perjury, Your Honor, the penalty for breaching such is contempt of court and sanctions. That was always part of what the state intended to have an expert sign here. And then in addition to address Meta's claim that it needs additional protections that are a bit departure from what is normal in this course, especially in the abstract, Your Honor. And to give this court something to be able to grant that it's a middle ground between the parties that should protect Meta more than what would be without this provision at all, if that's how Meta stated it, would be to, in addition to this Exhibit A, have an affidavit from said expert that correlates with what you saw in sub B and sub C of the Massachusetts order, Your Honor. And that is a written statement that they're not a current officer, director, or employee, and including the court's language, the Massachusetts Commonwealth of Massachusetts court's language, consultant to or expert for a party or a competitor of a party not anticipated at the time of retention to become an officer, director, employee, consultant to or expert for a party or of a competitor of a party. And then also to obtain, that would be part one of the affidavit. And then part two would be that an expert, a written statement that he or she is not involved in competitive decision-making on behalf of a party or a competitor of the party, Your Honor. So
you want me to do what Massachusetts did? Is that what you're saying?
I believe that it is a good middle ground, Your Honor. It is something that has already been done. The court mentioned earlier not wanting something to come out of the state of Nevada. That is a concern of this court because of all these other places that this provision has been entered as part of the protective order. And so the state is presenting something here that has been done. Instead of having that provision entered, this was a balance another court struck, Your Honor, believing that it adequately protected Meta and its proprietary information.
Okay. Can I pause
yes,
you
you
for a
can, Your
second?
Honor.
Because one of the main issues that appeared that you raised in your opposition was that you had to unfairly disclose an expert before the time for expert disclosures. Doesn't this do that?
It does not. Thank you so much, Your Honor. That's one of the major points I meant to bring up, but neglected to. The state would, everything else that I have said holding true, the state would not turn over such affidavit. It would instead retain it in its records such that to the extent, and not that the state would expect this would happen, an expert were to breach, they would be liable directly to Meta because it would have a copy of that. The state would produce a copy of that affidavit.
Are you saying that's what Massachusetts required?
I believe that is exactly what they required, Your Honor, that they did not actually turn over the
Please point to where and what has been provided to this court that says that, please. In essence, and then you're taking away Meta's request to have a process of objecting of anything being submitted.
I am, Your Honor. This would all be in lieu of this
So let me
process.
finish a sentence.
I apologize, Your Honor.
We're correctly anticipating where I was going, but my wonderful court recorder keeps looking at me because we all want to make sure you have a clear record. And if you keep interrupting, then we don't get you a clear record. Thank you. Okay, so you were going to show me where in the Massachusetts protective order it stated that the Commonwealth could maintain it and not provide it.
I cannot point to that in the protective order, Your Honor, and I do not want to provide any argument here or any supposition here, Your Honor, that is out of line. That is my understanding of how they handled this in Massachusetts, and I think that it would be appropriate to do here. Counsel for Meta may be able to answer that question for you, Your Honor. Not asking them to do my job for me, but they may have the information you seek. However, Your Honor. Okay. My co-counsel here is. Apologies, Your Honor. referencing that same provision that we've been talking about, Your Honor, sub B, page 17 of the Massachusetts protective order, Your Honor. You there, Your Honor? Okay.
Yes,
Halfway down the paragraph. Moreover, in the case of consultants or experts who are retained specifically employed by a party to prepare for trial or who are not expected to be called as a witness at trial, other parties may not, by interrogatories, deposition, or other mechanisms of discovery, discover facts known or opinions held by such non-testifying experts consistent with the provisions afforded in the facts and opinions under Massachusetts.
There's an and there, right? It's employed by a party to prepare for trial and who are not expected to be called as witnesses in trial. So isn't that a sub-qualifier? That paragraph only applies to witnesses that are not going to be called at trial. It's not applying to all experts, right?
I believe that should be the part, Your Honor.
No worries.
I'm also terrible at reading handwriting, which is not helping in the current situation.
Are you all gonna want multiple people to talk on your behalf and I should be doing multiple?
No, Your Honor, I'll just be handling it.
I'm just trying to find the most efficient way to get this taken care of for everybody.
Your Honor, I'll point the court back up to the top of that same paragraph, sub B, Your Honor, for your sub B, Your Honor, for the avoidance of doubt. Attorney, expert, communications, work product, working papers, notes, draft reports, and any other material exchange with any experts retained or specifically employed by a party in this case shall not be subject to discovery or disclosure, consistent with the maximum protections under, in this case, the federal rules of procedure 26C and the Massachusetts rule. So I believe that this language, Your Honor, is stating that the maximum protections and not subject to disclosure would be including the names of the experts that the Massachusetts court is directing to sign these affidavits.
It doesn't say that, does it? And Nevada has a different rule with regards to working papers on experts than Massachusetts does, doesn't it?
Yes.
You may not be familiar.
To the extent that I am, I believe that's correct, Your Honor, but I'm trying to provide the court this middle ground that I believe the state believes should protect Meta in the way that it wishes to be protected without having the state have to disclose all these experts for any highly confidential information or materials. The state has not seen any highly confidential materials yet, and instead of having to go through motions practice and notice requirements when this happens, we believe that at the outset, if the parties are able to, in this case it would be parties, but the state for the particulars of this argument is able to obtain both this agreement to be bound and the affidavit, right? Because the agreement and acknowledgement to be bound would not be turned over to Meta either, Your Honor, because that would be disclosure.
But isn't that inconsistent with the draft proposed protective order where it says anybody who's bound by the protective order needs to sign that, right?
You sign it, Your Honor, but you wouldn't disclose the names of the individual who signed it because that would go against Nevada disclosure requirements. It is my understanding, and if that understanding is incorrect, I would ask the court to allow one of my co-counsel to chime in on that particular point.
I'm hearing what everybody's saying. I've looked at and reread it again during your break, right? This proposed protective order, but can you maybe appreciate that both sides are telling me things are inconsistent with the language of the proposed protective order on the supposedly agreed upon portions, including paragraph 25, including paragraph 32. So what is the challenge that the state has, okay, with regards to your expert names are going to have to be disclosed?
They are, Your Honor.
So knowing that you're hiring Jane, Jack, John, Jeff, whatever, at time blank versus the date that you actually provide the expert disclosure, what is the harm that the state is saying exists in that? Or harm, the prejudice, whatever word you would like to use?
It has to do with the early disclosure, Your Honor, as the court pointed out, that's the issue versus disclosure when it would regularly happen. Disclosure nonetheless, it will happen, it's just a timing mechanism. That's what the court's pointing to. The state's issue with that is it creates an opportunity for Meta to then object to disclosure of this expert material to this witness or this expert.
But those
Sorry,
are two
this
separate
highly
concepts,
confidential.
right? Those are two separate concepts. One concept is the disclosure of a person's name in their CV. That's where the question, that's part one. That's the court's question right now. What's the harm or the prejudice to either side? And that goes back to the fact that most likely some of your experts are already being used around the country and both sides have a good idea who's coming in, wants to come into this case. Not saying they are, who wants to. I'm not making any advance rulings on anything, right? But so what is the harm of them knowing it's Jane, Jack, John, Joe?
Well,
whatever?
just in the disclosure, I apologize. I think I cut the court off again. I like to get started early. I'm sorry, Your Honor.
Go ahead, please.
I believe the harm in the early disclosure just itself, Your Honor, is that it would give the other party disclosure in advance of what the disclosing party would then have its normal protections under Nevada law, giving the other party more time to plan when that would normally come in with rebuttals or in the timing for that. But I do think the larger harm lies in that disclosure then has multiple steps, as we discussed earlier. Within 7 days of disclosure, there's an opportunity to object, which can lead into motion practice and delay in the state utilizing its expert in that
We're
regard.
walking through the real world, right? It would be wouldn't it be likely that Meta is going to want to disclose its own highly confidential information to its own experts?
Absolutely, it will, Your Honor, and
So
that's
then, so that's the, right? Then they would have to let you know their own John, Jack, Jane, whatever, I just picking a couple of J names, okay, it doesn't really matter, right? They'd have to provide you that same CV and that same name. Right? Because there's no preclusion that if they've already designated an expert, or they've already reached out to someone, right? It's as soon as you want to do any information. And that means anything that they've marked highly confidential, so if they overmark things under your analysis, right? Then they have made the universe of when they have to disclose to you, their expert, a lot broader. Right? And the concept that they might be able to rely on individuals versus experts. Isn't there a self-guided protection there on the standards of experts can offer opinion, Nevada law, right? On what a lay witness can say versus an expert can say? And if there's nothing here that says that somebody can say, well, because person X works for the company, they can be treated as an expert for some purposes in offering opinions, but yet can't be treated as an expert for having the obligation to give their name and their CV. Right, because there's nothing here, there's no treating providers. That anybody's telling me in this case, right, but sorry, since Nevada has a specific aspect, right, with treaters not having to be designated as experts in certain contexts. So if they want to use any of their people and they want them to offer any opinions versus lay testimony, right? Or they want, then wouldn't they have to disclose the same name to you? Or you? I'm just really struggling with how there's any prejudice on knowing people, when particularly there's only a small group of people who have this aspect of knowledge. And guess what? If you're reaching out to John and they've already reached out to John or Jack or Jane or whatever name, okay? I'm not in any way implying anything by saying those names. It could be Hector, Amon, whoever, it really doesn't matter. They're going to have to tell you, sorry, Meta's already reached out to us. We can't help you, right? Or if they try and reach out to the person, sorry, the state of Nevada's already reached out to us. Sorry, we can't help you. So they're going to find out anyway. So I'm really struggling. I understand your concept of an additional processes for objecting, okay? But I don't really see how providing the name is any prejudice to the state. Or because Meta's gonna have to do it, and they're gonna have to have experts too. And as soon as they want to hand over any piece of that documents, right? Because guess what? You can depose any of those people. And if you find out that they have any of those highly confidential documents, your first question likely after their name and right, their position is going to be, what did you review in preparation for your deposition today? And if it's any of those documents have a highly confidential stamp and they haven't provided you that information, somehow I can imagine that's going to come very quickly before a court. And I can probably appreciate the court would not be very happy if that all of a sudden happened after representations were made as officers of the court to the court, right? So I'm trying to find the beef in this sandwich, right? Prejudice is what? Just giving the names does what?
Yeah, yes, Your Honor. I'm just trying to make sure you finish before
Oh,
I cut
I
in.
I am on this one, thank you.
No, thank you. Almost several times there I spoke, so, thank you, Your Honor. Yes. Well, as to the particular, prejudice, Your Honor, the early disclosure means that Meta could start prepping materials for cross-examination, way sooner than the state could, because, the states, haven't disclosed that information. And what if Meta produces documents, 30 days before the, initial expert deadline, and then objects under the provisions that
I'm
we've laid out?
stopping you on the objection part. I'm trying to break this down from prejudice, the naming the names. I fully understand everything you're saying on the objection process. It might add some extra time. And you have a concern about them having a global concept of anything highly confidential, okay? That's why I'm trying to narrowly focus it on the name disclosure and this CV. I mean, no, whether or not, or a webpage, right, or something.
Yes, Your Honor. I can speak directly to that point, and that has to do with the fact that this provision does not differentiate between testifying or consulting experts, Your Honor. And under the NRCP, the state would not be required to disclose its consulting experts, only the expert, the expert that expects to testify, right? At that 16, I'm doing this from memory, Your Honor, A2E, I believe, disclosure, the 90 days. Not
15 is amending pleadings, but it's okay.
did I say 15? I meant it's 16, Your Honor, 16.1. I have it written here, 16.1 A2E, should have looked down.
No worries.
So yes, no differentiation between experts that are testifying and experts that are only consulting. That would be disclosure that would prejudice the state, because it would not otherwise have to produce that
The
information.
name, just
The name, yes.
Okay.
Your Honor, before, it seems
5
like
minutes
you
to
might
wrap
tell me
up,
to.
and then I'm not gonna ask any more questions, and then I'm gonna go to Meta so that I can hear their last few minutes of final words, and then I'm gonna make a ruling. Go ahead.
Okay, Your Honor, yes, and you did suggest earlier, that this may be something that we talk about in front of the special master, and we agreed to do it here in court. If the court believes that there's too many, conflicting provisions in the protective order, as you say, with 2532, 45, I believe, Your Honor, that the state would, be happy to undertake the meet and confer responsibilities with Meta to provide something else to the special master that is more in line with those particular provisions and no conflict, Your Honor.
Thank
I
you.
will wrap up, and I appreciate you giving me the opportunity to do so. And I'll do it and actually, incredibly quickly, I think. Because this is, to say the least, not where I was going with some of this. Your Honor, the state believes this provision is prejudicial for the reasons we've discussed. We believe it's inequitable, and just it is a significant departure from Nevada law. This is in the abstract that the state has no highly confidential documents yet. What Meta is requesting is unique, to be sure, and NRCP 26C puts the burden on Meta to prove good cause for entering this protective order, good cause for entering this specific provision, Your Honor. The state does not believe that Meta has met that good cause. Speculative harm, as I mentioned, should not be in itself good cause. Understanding that the court's inclination was to grant something to cover this issue, and the state wanting to provide the court something that it can grant, Your Honor, that would alleviate the concern. The state still suggests that, in addition to the Exhibit A acknowledgement agreement to be bound, this court enter the protective order as it is between the agreed upon portions between the parties. So, without paragraph 36, and in lieu of paragraph 36, and in addition to the acknowledgement and agreement to be bound that experts must sign, also have both parties have their experts sign an affidavit, Your Honor, under Nevada law that, and I'll, for the benefit here, that the expert, and I'll summarize instead of reading verbatim, it's not an officer, director, employee, consultant, or expert for a party or a competitor, and does not intend to become so. And have that expert sign that affidavit, Your Honor, and file it with the court, if that would be a good thing to do, so that it is on the record, Your Honor, but sealed, so that the other party would not have that expert disclosure, or the name of the expert would not be disclosed, Your Honor, but it would be in the record for the court to see who has signed this affidavit, and in addition to the acknowledgement agreement to be bound. And the state believes that there would be good cause for this court to do so under NRCP 26C and Venetian, including proportionality to the needs of the case, Your Honor, under 26B1 in Venetian, and the three-pronged test in Venetian for good cause. Your Honor, I will conclude there, and I thank you for this much time.
Thank you. Someone have a quick reference, oh, here we go. There's- I'm looking for the page, somebody has a quick reference for the court of where it first references the. This goes to the C. Experts
Where first references,
to the exhibit A. It looks like is the first reference to experts in exhibit A, page 15, is stipulated protective order, proposed stipulated protective order. Which defines experts who highly confidential from the eyes only may be disclosed to.
the first reference to the exhibit A in the protective order, the proposed protective order. I think that's paragraph 13, if I'm not mistaken.
Please, outside counsel. So under the proposed stipulated protective order in the version that was submitted to the court right now, is it correct that outside counsel, experts, and then the inadvertent disclosure, the clawback aspect, are the parties or individuals who would be signing the exhibit A, the agreement to be bound? Is there anybody else?
Outside counsel. experts
Outside
in a-
counsels in paragraph 13. Experts are on page 11, which is paragraph 31, sub C. Or professional jury and trial consultants also, so let's just say.
It's
paragraph
everybody
31.
that's in. There may be more people, including in paragraph 30, kind of description of various different individuals who may sign exhibit A, including jury or trial consultants, mediators, others. So the universe is larger than two.
Paragraph
references.
13, paragraph 31 for the universe, as well as the clawback provision, which is later on. That's the inadvertent disclosure. Vision.
30 as well. I think 30 as well. 30 and 31.
Thank you. Let me go back to 30. That's confidential, that's stuff. Okay, but there's still, so regardless if it's confidential or highly confidential, everybody's signing exhibit A, correct?
Correct.
Okay. So that leaves the question raised by the state of Nevada's counsel as to why that is not sufficient. If the person, separate and apart from whether or not you get a copy of it, I see that as a different issue, but why is that not sufficient? If they're signing the exhibit A and doing the affidavit that was suggested based on the Massachusetts Commonwealth of Massachusetts model, why is that not sufficient for Meta's needs?
In essence, the problem with that is functionally, there is no check or acknowledgement or knowledge from Meta or ability to object to anyone who decides to sign a statement saying that, oh, I'm not going to do this. The courts that have addressed this very same issue, including the California court and the Google case, and the other courts that have been evaluating it, have consistently looked at proposals about an expert unilaterally signing a statement, I won't share this information, and said that is insufficient to protect Meta's confidential information, highly confidential information, because Meta doesn't get a chance to object, and it's unknown whether this person has a connection or not, and whether they're saying that on the basis of saying, I can internally separate these things out and I won't share it.
Second,
Courts have recognized that's
may not have-
impossible.
maybe my question wasn't clear, right? The state of Nevada in its alternative proposal, middle ground, however you'd like to phrase it, right? Took the Massachusetts model, including the interlineations by the court, which required the individual to affirmatively state that they're not a consultant and all of that, plus the Exhibit A agreement to be bound. That's why I was saying, why is that not sufficient for Meta? Because if you add in the language from Massachusetts, right, that, because that was the part A, obtain the expert a written statement that such expert is not a current officer, director, or employee, consultant, or an expert for a party or competitor or party, nor anticipated at the time of retention to become an officer, director, employee, consultant, or expert for a party, a competitor or party, and C, obtain from such expert a written statement that he, she is not involved in competitive decision-making on behalf of a party or competitor of a party. Why would that not be sufficient? Because that would be the affirmative statement that you're saying that the individual would be making, plus the agreement to be bound.
Because functionally, it's just saying, trust me, don't worry, I won't do this. And courts have said that individuals who are experts and hired as experts in litigations like these are not, that does not go far enough to protect the interest. And let me point you specifically, I know the state pointed to the Massachusetts protective order.
Mhm.
Exhibit 3 of our motion is the order from the state of New Hampshire.
Right.
Well,
Stamp
the
61?
case in the state of New
Sorry,
Hampshire,
Bait stamp 61,
Bait stamp 61.
go ahead, please.
And in that order, the court recognized specifically in the last paragraph, the state has proposed a protective order that requires the parties to obtain a signed affidavit of confidentiality and certain written statements from any expert prior to sharing highly confidential information with them. And it goes on to
What
explain
page?
that,
Sorry, what, you're still on page 61?
61, and then turning over to 62 explains that it's the same language that's being discussed from the Massachusetts order. And it goes on to describe Meta's position, which is certain identifying information should be shared, and the state's arguments about it. And ultimately, the court says, the court is persuaded that providing information identifying each expert and the opportunity to object to them, which is crucial. The signature doesn't provide that opportunity to object, is necessary for Meta to adequately protect its highly confidential information.
But are you asking to object, see, and in reading this, right? Are you saying that this is to object to the expert or object to the expert having the ability to have certain information?
Solely the latter. We cannot object to the expert on the basis of this information. They may use whatever expert they would like to use. The only thing we're objecting to is the use of our highly confidential information with an expert like this. And this New Hampshire court goes on to quote the Ibrahim Ninth Circuit decision, talking about how commonplace it is for experts and consultants to be vetted so that trade secrets and other sensitive information won't fall into the hands of someone with an adverse position. The risk is simply too great that someone in such an adverse position will be tempted to misuse sensitive information for a purpose other than litigation. For example, a trade secret might be misappropriated by a consultant or expert and written into a pending patent application. So ultimately, the court said, there's just too much of a risk to say, I'm just going to trust a signature that doesn't have any process by which Meta is able to challenge or object to that witness having the kind of relationship that would address this. And so that's the reason why it's not enough for us to simply say they could just sign off a paper and now get access to all the highly confidential information. It also doesn't speak to the concern that you were raising about making a decision about who gets access to information based on a particular set of information that you described. And again, I want to be clear, they can show their experts all of the confidential information that we've produced. This is only talking about the band of highly confidential information. That's what triggers this issue, not the confidential information.
What is the vetting process to determine that it truly is highly confidential information? Therein lies part of the right this court's challenge. Now, I'm not taking the position of the state that they said, I mean, I don't know, did you de-designate things as highly confidential down to confidential in other states? Did Meta do that?
Oh, there have been times that under the protective order that we've proposed and that is entered in other litigations, that the state has challenged confidential, highly confidential documents. And there have been times where Meta has decided, well, we evaluated that challenge and the meet and confer process said, okay, we will de-designate this to confidential. And there are other times where Meta has fought that. I think ultimately that reflects a protective order doing what a protective order is supposed to do, which is if you have a challenge with something that's been designated, challenge it, Meta has a response, you meet and confer, and then if you need to go to the court, you do. And that's what we propose to have here. And the burdens are all laid out as to what happens with confidential and highly confidential documents. And we're happy to have those fights and go back and forth about what is truly highly confidential and what is not, if the state would like to down the road after the production has occurred. But all we're asking for in this instance is, and if we get to a stage where the state says, well, we want to show this is materials and you designate it as highly confidential, are you going to maintain that? We would evaluate it. And if we say, yes, we are, and we're going to challenge your ability to share it with the expert, then we get into court. If we say, no, we aren't, you can show the expert because we're going to de-designate it as confidential. There's a process for us to do that. All of that is perfectly appropriate. And I also want to challenge the question of whether we would, use this process and abuse this process. I think that the parties have worked together in this litigation and been and worked together to meet and confer fairly in this litigation. I can tell you right now, Meta has no interest and has not in any other litigation, and they wouldn't be able to say it has ever occurred that we have abused this kind of procedure at all in this litigation to this point. So
here's,
what I
why would you
propose-
not have? If you're raising an objection that you have to articulate by Bates number, which specific documents you are stating should not be provided to the expert? Because that would then balance the needs of the parties, right? And give the decision maker an opportunity to see what actually are the documents that are being sought to be objected to, so that it minimizes, not saying anybody would ever do it, right? But minimizes the issue of something's highly confidential, they then disclose, then you de-designate, or you have highly confidential. Why would you not, similar to a Rule 45 in Nevada, right? And have to put in your objection within the 7 days. We object to expert blank receiving documents, Bates stamp blank to blank to blank to blank. Now, if you've done it as every single document, then the person who's evaluating it, whether it be the special master or whether it comes to me as a report and recommendations, would look to see if it's every single page or not. But then you've actually, because that's your burden anyway, because you can't just say, we called it highly confidential, we get it, right? You have to say why the highly confidential documents would not be able to be provided to expert blank.
With the scope of documents that's been produced and will be produced in this case, it would be nigh on impossible to get just the name of the expert and say, of the highly confidential documentation, we're going to say this subset. I think that the reasonable and efficient way to
How do you meet your
this.
burden? And how do you provide to a court a burden on why they shouldn't see certain documents?
Well, they're not planning on providing them. Well, I don't understand the state to intend to provide their witnesses with every document in the litigation. If the state would like to show a particular set of
Oh,
highly
no, but that's putting the
confidential.
burden on them because, right? That means
Well,
they're
we
gonna have to
can
tell
do
you
that.
exactly, because you've got, your example includes consulting witnesses, right? Non-retained witnesses that may have a trial, right? They may consult somebody to get further knowledge in an area that you already have, because you know what I mean? You've got Meta, you already have employees in that area. They may want to, not saying that you're not fully knowledgeable on every single aspect of Meta's work, but you may not be, okay? So they may want to have an expert on certain areas, right? So if they want a consulting expert, it might be fair game to know who that consulting expert's name is, because that's not giving anything else away, right? Because you're not getting the content of their communications, but and whether or not they end up utilizing and disclosing as an expert report, then it stops right then and there, so you wouldn't get anything more from the consultant other than the person's name, okay? But if you're asking them to do a consulting expert, and they are gonna wanna give consulting expert documents 1 through 15, 67 through 1,000, then you're putting the burden on them to really show you their strategy and game plan, whereas the burden's on the objecting party to say that the expert shouldn't get something because pursuant to your proposed protective order, experts get documents unless there's some good reason not to give an expert a document, right?
Burden remains on Meta to establish whether or not the witness should get it, regardless of who identifies the set of documents. What I'm saying is the way we have it set up right now is that the highly confidential set is the set that we'd have to justify in any motion for protective order as not being able to go to this particular witness. And so we would need to be able to do that. And in the motion proceedings, if we were asked and the special master asked us, or you asked us, Judge
You know, I
Kishner,
will, if
to-
it comes to
to-
me, I'm gonna ask, you know what I mean? Why shouldn't they get a particular document? Because in order for me to make a ruling as to whether you met your burden, I need to know what you're asserting and why you're asserting it, and to actually see the basis of the assertion.
But we
Not-
wouldn't be able to just theoretically come up with what they plan to show. If they plan to show 15 documents and there's many more that are designated as highly confidential, would the burden be on us to establish that every document that's been designated as highly confidential, that they're not planning on sharing?
Just the ones you have the concerns about, right? Because if you have an affidavit, if I take, here's where I'm heading, okay? Let's be blunt where I'm heading, and then you all can each address it. Where I'm heading is taking the Massachusetts model, but keeping in an objection period, but putting that the objecting party has to say which documents that are marked highly confidential that shouldn't go to that expert. Because what that balances is, if you know Jane Doe, expert Jane Doe is in the area X, right? Then you only need to be concerned, right, that she's going to be getting documents that you're concerned. So you would have an affidavit that says she's not a competitor, et cetera, et cetera, et cetera, under penalty of perjury, which puts her fully in the court's jurisdiction, but subject to sanctions, et cetera, personally, which normally an expert doesn't have, okay? And that's on either side. So that puts that burden on them to say that they're not going to do it. And remember, I'm not going to anticipate that somebody is going to disclose things without any basis, right? Someone's gonna have to show it to me. The same thing as I don't presume that attorneys act inappropriately unless somebody shows me that they have, okay? I give everyone the benefit of the doubt, as I should as a judge, fair and equal. But if I put the burden on the person objecting to say that this person shouldn't get documents, then that is the fair thing to do, because only you would know which documents you're concerned about for that expert to give. If I just say highly confidential, what that really does is incentivizes somebody to mark everything as highly confidential and put the cost and burden on the other side to try and contest it. And what I'm really proposing is Rule 45 in a different fashion.
We're not proposing that they would have a burden to do anything. And I think even under any discovery rule, the party that wants to share the information identifies the information they want to share within the world of what's been produced. It's not the party who's produced documents just guess and say, well, we need a protective order for every document or for this theoretical subset of documents. And then the other party has to say, oh, well, we aren't going to show them any of those, so we're good. I think that it's only if there's a need for specificity, it would appear to be the most efficient way if the state's going to provide a certain segment of highly confidential documents for the state to say, we're planning on providing this set of highly confidential documents. And
Then they've given away their game plan, or you'd be doing the same thing. You'd be saying, look, we have a consulting person and we're only going to show them these documents. I can't see how this court can order that, because that was inconsistent with Nevada law and consulting documents. I can see it on a non-retained expert to have a general concept that if you're objecting to certain documents that you let them know that you are, because you'll know the name of the person, right? You know the name of the person, you've already got the affidavit to say they're not, but if you still have that concern, then you have to say what your concern is relating there too, because otherwise, I don't see how you can possibly meet your burden if it ultimately comes before a special master or a judge, because they're gonna have to ask why these documents, and if your response is just, well, because we marked them highly confidential,
No,
then
in the briefing process, we would have to answer the question of.
you have to relate
why.
to specific documents. These documents have this type of information in it, right? These documents have that type of information in it. And with regards to this expert, because this expert has this background, we then feel that these documents, you can't just say, because we marked them highly confidential. I think that balances that interest and really clarifies the process so that you don't have a whole bunch of objections, not saying anybody would do false objections, but I see it really consistent with Rule 45 that you have to. That was pardon? Oh, someone's using the Sally port. Okay, got it. Thank you.
Just so I understand, Your Honor. What you're saying is, the description of what you've said is. There would need to be some kind of affidavit that would be submitted to the court, and there would be a disclosure to the other side, the names. And CV would be disclosed. And then there would be meet and confer, and then the protective order motion component. If Meta is challenging this particular witness, Meta would need to identify what documents they're concerned about this witness.
Similar to what you would do with an attorney-client privilege log, similar to what you would do with regards to, like I said, Rule 45. I see that consistent with our Nevada law. And the only thing it's doing here is because of and I also see it consistent with an analysis any jurist or special master is going to have to take into account. It's similar, and once again, I'm not saying it's specifically Rule 3, but it's similar to that same concept and it is consistent with an attorney-client privilege. Like you can't just say, we're calling it attorney-client privilege, and so therefore we get it. You have to explain why it is, who the people, you know what I mean? It gets challenged. And so I see all of those bases gets you there, and by having the affidavit concept about not being a consultant expert, et cetera, similar to what's on page base stamp 16 and 17, i.e. from the Commonwealth of Massachusetts, gives the other side the first level of confidence of, look, this person's made these assertions. Am I comfortable with these assertions that this person's made under penalty of perjury and fully submitting themselves to the jurisdiction of the court, right? Because if they do it, they got issues, okay? Well, I'm still concerned. Well, then you have to say, well, I'm concerned, that I'm gonna have to point out why I'm concerned with these particular documents. And it gives the incentive to raise the issue when it truly should be raised, rather than, not saying anybody would, but raising the issue for almost any expert. And it balances the need of why, because you're gonna raise the objection, right? Then it goes with regards to that particular expert. You've just got their name, you've got this generalized information. I don't agree with the state that they should be able just to keep it and not provide it, because even with non-retained experts, just having the name, I don't really see a prejudice to either side, because you're not giving the content of the information. I don't see the basis of making the person who wants to give the information say which documents, because I think that really does give their strategy and game plan, and that's not fair to either side. But if the objecting side, you've got the burden anyway, you're gonna have to establish why, and you can't just say it's all documents. You can't say 10,000 documents shouldn't be given to this expert because we say so. I'm not saying anybody would, right?
We'd have to justify it.
But if you justify it right up front with your first objection within that 7 days, then you've taken the decision is this worth this for whoever the us is, whether it's the state or whether it's Meta, that we truly feel, and then the court's got something to look at, which it's going to need anyway to do an analysis. So other than you don't like that idea because it adds a little bit of cost burden to your side. And I see it meets proportionality with Venetian because it's giving the objecting party the obligation to do that extra cost and expense rather than the non-objecting party. So it meets our Venetian test. What's the issue? And then I'm gonna give the state a moment and you can have final word. If you want them to go first and you go last, that's fine, but I'm gonna give you each a few minutes to respond.
Well, can I say this and I'll let the state go on? We put in our brief and we maintain that the proportionality piece of it is a reference to disclosure to the public, rather than what's going on here, which is a different kind of question. And it's that the subsection C is the applicable kind of analysis, and the good cause analysis is the one that directly applies. We think we've shown good cause for the provision that we've put forward. I understand your Honor's description. I think there is a practical problem or consideration in a case that involves this number of documents with this scope of discovery to be able to kind of theorize and identify what subset of those documents would be of concern just by having a witness's, name and CV. And so that's the concern that I'm putting forward. But otherwise,
You also have their affidavit that they do not have any of those relationships, and so you're gonna have to show that they do anyway to the special master and or the court, aren't you?
but we understand that we do have a burden to be able to justify why these experts would not be able to receive highly confidential documents. And I think we can do that by reference to particular documents in the production. It just is difficult to do that in the scope of all of the highly confidential documents in the case, when highly confidential as a category is defined as having the risk of potential harm as defined under the protective order. But we understand your Honor's comments. I'll let the state
Sure.
kind of proceed, and then I will respond to them.
Okay, state, you want 2 or 3 minutes, or you want me to make a ruling?
I'll take just a moment, Your Honor. I'm not taking much time. Matt Bush for the state of Nevada, Your Honor. Appreciate the court's consideration on this issue. Just so that I'm clear on drawing a conclusion here. The state is suggesting that it would require parties to obtain an affidavit from any experts, Your Honor, consulting or testifying, and then produce that affidavit to the other party, Your Honor.
Only if you're planning on providing that expert highly confidential documents that have already been provided to you. So let's walk it through.
Yes, Your Honor.
Let's make my life easy with numbers. Say there were 10 documents, right? Stamped highly confidential. If you wanted to retain an expert, whoever that expert is, and you wanted to show them 1 or all 10, okay, 1, 2, whatever, up to all 10 in my example of those highly confidential documents, then the following would have to occur. You've already got it that they have to do the bound to agree, the exhibit A. That's really a non-issue, so that's not adding anything, okay? You would do the sub B as in the Commonwealth of Massachusetts, obtained from the expert a written statement that such expert is not a current officer, director, employee of, consultant, and or expert for a party, competitor of a party, nor anticipated at the time of retention a consultant to expert for. So you take the language under B in the Massachusetts order, okay? You take the language from sub C from the Massachusetts order, obtained from the expert written statement that she's not involved in competitive decision making, okay? And you put that in there. I probably would suggest that you would add something that if that changes, they have to notify everyone, right? Because realistically, if they get a new job, they've got to notify everyone from both sides, because neither side wants to be surprised by that, right? So there's an ongoing, basically add some language, an ongoing obligation, right? If the status changed, they have to affirmatively notify. Okay, so I would add that. Okay, so that's what your expert, and then you would need to provide just the name, whether it's a CV and a website, right? Or their title and their company, right? Something bare minimum, not what you have provided them, and not, in my example, since I said there was 10 documents, you don't have to say we want to provide them highly confidential documents, 1, 2, or 3. You don't have to do that. You just have to say name and everything I've just said. Then, within 7 days, if the other side, and since this example, it's you doing an expert, right? It's the state. Then if Meta has an objection, Meta would have to, consistent with their 7-day objection language, but would have to say that they highly confidential, and there's 2 alternatives, which actually I have to flesh out a little bit with you all. Is one is it's actually in writing that says, these highly confidential documents, blank, 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 and blank in their objection itself, or if it's done during the meet and confer process. It seems to me it might make more sense to do it in the 7-day objection process, because then when you meet and confer, you might just come to an agreement. Guess what? maybe they're really only concerned about 1 and 2. They're not really concerned about 1 through 10 or 1 through 9. Okay, but the burden is on the objecting party to put the confidential documents that they are concerned about by an initial base stamp range, right? The same way that they have to do it on attorney-client privilege law. It's really, okay? And they wouldn't have to give an explanation of the reasoning in the, right, but they have to give, let's go to 36. Okay. So 7 days, the party receives a written objection. Any objection must set forth in detail the grounds upon which it's based. So do that language, plus identify by bait stamp number the range of highly confidential documents. And realistically, if they're objecting to all of them, yes, they could potentially put all. Okay, I'm not limiting it. Please let me finish. Okay, I'm answering the question, then I'm giving you a chance. Okay, so then party receiving the timely objection, then you have to have your meet and confer, right? That keeps the time period for a meet and confer seems appropriate with 14 days. I mean, whether you all disagree and want something shorter, it really doesn't matter. I can't imagine something longer because of the timeliness issue to get the information to your experts. And then the filing of the protective order, because then you both would have, for purposes of what you present to go to the special master first, you already have what the range is, the same way as you would have it if you're objecting to attorney-client privilege documents. It's similar to the way that you'd have it if you're doing the front end of a Rule 45 subpoena. So I'm trying to take current rules with current things and apply it to your circumstance and situation, but tailor it to your unique circumstances. Okay, so then it's consistent with the burden being on the objecting party to at least identify what type of documents, because guess what? You might have in your meet and confer, well, look, we don't really need to give them these highly confidentials because now we're kind of understanding your situation. The other side might say, well, okay, now that I know more about this person during the meet and confer, maybe I don't have this concern anymore. And then, so the rest of the process in 36 would be the same as far as the timing. And it goes to the special master with the report and recommendations to this court under the objection provisions of a report and recommendations, which will likely be in a CMO that you've not yet had a meeting with your special master, but it'd be tied to a CMO aspect with regards to a report and recommendations coming to the district court if needed, if there was an objection. And that can be done quickly and efficiently, so you don't have your issues on timing. It's not giving more information. As far as it going to both non-testifying experts and consulting experts, the challenge there is unless you say specifically upfront, there is no way that this individual is going to be a testifying expert. I really think I have to consider it to both because the risk of harm still exists with both type of experts. And since you're not having to provide the actual documents you're providing, you're not giving your, like, look, we need to know more about how this scrolling mechanism, right, works, or how this newest beta version is doing something. And I'm not going to go into the newer beta versions and things like that people have discussed in other hearings, right? You're not giving any of that information. You're just giving the name and the expert. So I don't see a prejudice. Does that answer your question on what the court's anticipating?
I believe so, Your Honor. It sounds similar in language, of course, to the provision that the state objects here today with the noted differences that Your Honor made, still the 7 days, the meet for the protective order, Your Honor, and still disclosure of the names of those experts for testifying and consulting. But appreciating the differences Your Honor pointed out. This discussion, Your Honor, before this court, the discussions that we have had, the parties have had, good discussions, Your Honor, really good counsel on both sides for many meet and confers. All these discussions are in the abstract because we have no highly confidential documents that have been disclosed at this point to really be able to talk about this as parties. So the state objects to having this provision entered in the abstract without Meta having to bear the burden of presenting documents to Your Honor, to the court, that it states.
Where's that in your opposition in a pleading before the court already?
I'm sorry, Your Honor.
Where's that argument in the pleading in the opposition? But this is a hypothetical.
It is a hypothetical, Your Honor.
Sorry, where is it in your pleading that says?
In our opposition.
In your opposition. I was, doing this for almost 3 hours.
It's been a long time, Your Honor. I
In the
appreciate
hearing
that.
to raise a new issue at the 3-hour mark when the court already has given you, just saying, if you wanted a few last minute words on where the court was heading, if you wanted to respond, you can appreciate the court would have a concern about raising a new argument at this juncture.
I would, Your Honor, and I
That's why I'm
apologize.
asking if you think it's in the brief, let me know.
I have perused where I thought that it would be, Your Honor, and I do not see it, so I will happily withdraw, Your Honor. I did not mean to set us on a different path here at the end. And closing words, Your Honor, matter should bear the burden under 26. C1, the state's concerns are just with the sheer number of highly confidential documents, how often this provision will come into play, Your Honor.
But then they're gonna have to detail which documents they're referring to and justify it. See, that's the self-imposed way to minimize if somebody wants to do it a lot, right? Then they're having to take on that time and expense to do that. Similar to what they'd have to do. It's effective usually with attorney-client privilege logs, right? Because people have to justify all those. And so it seems that's, I'm just trying to explain why I'm coming from that angle.
And given my experience, Your Honor, privilege logs are very time consuming, and so I understand your Honor's point. With that, Your Honor, I believe that I'll close. I appreciate the opportunity to speak to this court today and taking into consideration the state's arguments and concerns in this matter.
I do have to ask you one question.
Of course, Your
One more. Paragraph 32. Is that intentional by the state? to
Is that
be in
the
there?
opposition, Your Honor?
Oh, sorry, paragraph, let's go to, sorry. In your proposed protective order, you heard me ask some questions, of Counsel for Meta, on paragraph 30. I'm sorry, I don't mean to say 32, give me one moment, please. Yes, it is 32. I did, okay, I have it correct, saying 32. Page 32 on page 12. The court asked the question of whether or not paragraph 32 seems to be contrary or inconsistent, whichever word you would like to, with the proposal of a highly confidential, since paragraph 32, do you have it handy?
That's you,
Page
Your Honor. I'm
16.
sorry, I just got to it. Can you please
Sure.
repeat your question?
Page stamp 16, page 12, paragraph 32, starts at line 10.
Sorry, Your Honor, I'm on exhibit 2, not exhibit 1.
I'll read it. I can
Thank you,
read
Your
it.
Honor.
Yeah,
I'm
no,
now
I
here
can-
32.
Nothing contained in this order shall be construed to restrict or limit the use, dissemination, or disposition by the designating party of its own information that it designates as confidential or highly confidential - attorney's eyes only. So is that intended to have that global waiver from the state's position?
Your Honor, I read this as contrary to paragraph 36 that we've been discussing, the provision I believe Your Honor did as well earlier.
That's why I was asking.
Yeah.
questions of Meta.
Yes, Your Honor. The state absolutely agrees with this paragraph, that the paragraph 36 restricts the use of in this case dissemination or end use of the designated party's information that it has designated as confidential, in this case highly confidential. So we read these to be drawing opposite conclusions, Your Honor.
So is it the state's contention that paragraph 32 is really your position versus the paragraph 36, which is Meta's position?
That would be correct, Your Honor.
Okay, I'm just, I can't sign something that's inconsistent, right? So I just need to make sure if there wasn't something I was missing in that regard. Okay, you got a full opportunity?
I have, Your Honor. I
Over the last
appreciate your time.
3+ hours, okay. Counsel for Meta, I promise you 2 minutes for your last and final word.
Yes.
Go ahead, please.
Final word, and I'll be specific to the point that you were talking about. First, in terms of the disclosure provision, one thing we would ask, the objection process, one thing we would ask is that either Meta be allowed to describe the documents in categories as opposed to identify every single Bates number at the objection phase, while recognizing that there may need to be specificity with every single Bates number at the protective order phase of the process. Because
How
the
would you be able to
7,
do a meet and confer then? How would the state, in this hypothetical, or the flip, if the state was doing it, the state's saying it's not gonna do it, so I'm asking you, is how would that allow to be a fruitful meet and confer?
I think both partners are in a tough spot with the meet and confer because we don't know, one side doesn't know what the other side plans to show their expert. And
Which is why if you put the Bates stamp numbers, they know and everyone's on the same page. That's really where the court was going with that one, right?
right. Oh, I just don't want it to be deemed as some kind of waiver or problem if there's another Bates number that might be included in the category of documents we're objecting about, that we just didn't identify at the objection phase. My main concern is that it's a 7-day time frame. There's gonna be a lot of documents that are out there. And if we're gonna go through this process, I just wanna make sure that there's the ability for us to be able to address and identify further Bates numbers within the categories of things that we objected to.
In the real world, doesn't each side already have an idea of what's going to be their super confidential or highly confidential attorney's eyes only documents? Because this is not the first case being litigated throughout the country. So you would already have an idea of what is your highly confident. See, that I have to take my real world example, right? I mean, is that you already have an idea of what you've designated in other cases as highly confidential. You know the nature of those, right?
Yes.
Your processes and plans on what you plan to do potentially might be an area. Okay, you all mentioned that, right? So that you would know those. To address your specific question in two different ways, I really could see two different things happening. One, you have the concept of the inadvertent disclosure or the failure to disclose, which you would bring before the person that you're eventually want to file a protective order and say, look, we did all these, you still got the good cause excusable neglect for inadvertently omitting, you did Bates stamps number 15 through 46, or you excluded 45 and you really meant to go to 46, right? You have that before anybody, to provide that. I think that is a self-resolution aspect, right? I think you also have the situation that you already have knowledge of what is highly
What we don't
confidential.
have is who the expert is gonna be and what area they're gonna be working in. And if you're saying
I
that
don't
it's
think
7
that the
days.
complaint says the areas and the causes of action and what they're gonna have to establish and what they can establish with lay people versus what they can need to establish. Because I recall from earlier hearings, you all told me that a lot of their complaint was, I think you used the word, I don't think you used the word cut and paste. I think you used a more polite word, but in essence was very similar to other litigations that are already happening throughout the United States, right?
That
Even
is
that was
true.
part of the arguments that came up before the jurisdictional discovery, right? And whether or not this court should even have this case. And so what I do listen to everything you all say, right? And
I
absorb.
think there's something different with the experts who are being put forward, especially new experts that haven't been put forward in other litigations that are being put forward for Nevada and not really knowing much about them at all, except for their role at their university or wherever they work, for us to be
But
identified
if it's
every single
if
document.
they're got a role at universities teaching economics, okay, they're economics. If they're teaching biochem, giving a silly example, right? Then they're biochem, the scope of those. And I just,
You
and since the-
described it as akin to a privilege
law.
law. I would never agree or to produce an entire privilege log that contains every single thing for a document within, a 7-day time frame for the first time I'm realizing the particular area that's being addressed.
but here's the difference between a privilege log, right? And this, and this is why I don't see it as reasonable and why I've said the affidavit requirement and the name requirement is because what you already have is you'll already have that person's name. So you will know their scope and the general area of expertise that they are potentially being an expert, right? Like that goes back to if they're teaching biochem, they're not coming in as an economist under Hallmark or, okay, and unlikely to be designated because they would not come in under Hallmark. That's not a ruling, because there might be examples that somebody has a dual, in econ and biochem, but so whatever. That being said, so you already have that, plus you have the affidavit. So what you really have before you're making an objection, is that you have to have the belief that you think you can meet your burden to establish the person in which you're contesting should receive this information outside the norm of they normally would get it as an expert, okay? In almost any other case, is that you have some specific concern to that individual based on that individual who you already know their name and you already know that they said they're not going to do anything, they have no connection, but that separate and apart from that, you still have a legal basis that you feel you can ultimately file a protective order that says that they should not get those documents. And in that very limited scope, that is the situation. So I really don't see it as an issue because I don't really see it coming up that often because
Right.
you can't just the experts the experts you already will know that name and you already know their information. So then you've got the category of new experts, right? The new experts, you're gonna have enough that you can research it, do all of the research. Meta might have some resources to find out about people. Maybe.
It's
I
true.
mean, you understand, you're not
I-
telling me your mom and pop shop,
I
okay?
understand.
And I have to look at this
But the
case.
challenge is not based on their expertise. The challenge is based on their access to highly confidential documents and their relationship to wherever they were, wherever they have a connection to. But I understand your honor,
Find out, I mean,
If
even if
to
the
the
person's
extent
name
that
is
we
John
find
Smith
out-
and there's a lot of John Smiths, I mean, I'm sure Meta can find out where it says John Smith's either got a CV or says their place of work, et cetera, right? They're gonna know if John Smith is a veterinarian or John Smith is, teaching
let me put it this way.
RSICV chips or something, right?
To the extent that we find in the meet and confer process that happens, there are other or additional areas or issues that come up. Meta can address that in the protective order motion that it files with the court, identifying the documents that are at issue. That's all.
So
I'm
your
suggesting.
ask is what? Let's be clear. 'cause-
That the objection does not have to identify every possible document that may be challenged in the protective order, but it must identify the categories of documents. And that Meta in its protective order will follow up and will have to justify to the special master and ultimately to your honor.
So what do you mean by a category of document?
What I mean
Documents
is,
that discuss our processes, documents that discuss IT, documents that discuss Meta, I mean, categories can be.
categories that
also can be-
relate to the connection that the expert has with whatever competitor or whatever the issue is that caused the objection.
How does that get you to a realistic meet and confer? See, meet and confer on any motion eliminate, right? You got the topic. You discuss the meet and confer on the issues you gotta articulate and it's gotta be specific. If you're raising a 45 objection, you've gotta know the topic and you've gotta raise it, right? And you have to say specifically what is confidential, what is attorney-client privilege, you gotta do it. If you're raising, going back to my attorney-client privilege, you have to actually say why it is attorney-client privilege without giving the actual privilege. What I'm saying is really consistent with every other processes that happens. What I'm hearing what you're saying, I'm not seeing how it gets you to a fruitful meet and confer.
Understood, your honor. Understood. Right. So in essence, it would be akin to a document request that identifies categories of documents or issues. And then you have a meet and confer about what the means and bounds of those are. But your honor, I understand and I know that I only had 2 minutes. And I know I'm
Lawyer
past
minutes,
that.
each side's getting there way more than 2 lawyer minutes, right?
The last thing I'll say is just that
The last thing in your 2 minutes is already way past. Go ahead.
I don't see 32.
Pardon? Go
I
ahead.
don't see paragraph 32 about how a designating party uses its own documents
Because it includes
as
highly
being-
confidential documents.
as being the
This-
same as challenging how the other side uses a party's, a designating
Because
party's
you stated that
confidential
it's equal to Meta and to the state. So even it's your own experts, that's where it is. It's your own experts. Under this provision, if you have a highly confidential document, paragraph 32, the way
documents. You
I'm
have to
reading it.
disclose.
No, it doesn't say you have to disclose. It says you can use it for any purposes whatsoever. Nothing in here is intended, right? So what this paragraph 32 says, that we Meta can give whatever we want to, if it's our documents, including highly confidential documents. I see that as inherently inconsistent with paragraph 36 that requires that you have to disclose. And so I'm not going to sign something that's inherently
We can
inconsistent.
include a provision that acknowledges the proceedings in 36.
The challenge really is your first couple of words, huh? It's really your first couple of words, nothing herein contained. I mean, folks, you can modify this to make it work.
Absolutely,
I mean-
except in paragraph 36 or something.
Yeah, I mean, it's the language, like I said, nothing contained in this order shall be construed to restrict or limit. That's a challenge because paragraph 36 does constrict and limit,
It requires us to disclose the other side.
which restricts and limits, because it means if you're going to give it to your expert, you have to disclose to the other
Right,
side.
right.
That is a restriction.
Understood.
That is a limitation. I cannot sign 32 the way it is. Please
We will,
modify it.
we can modify, we're happy to modify 32 and 36 in line with your.
Okay. So. Ruling. Everything that I just explained as far as what the court is intending to do is your ruling. Okay, I find, so I am granting in part, let's walk this through order of language, right? I am granting in part Meta's motion. I'm granting it consistent with what the court stated, which I'm not going to repeat everything. I'm going to just do the quick version paraphrase. You're going to include the exhibit A. You're going to include the provisions from Massachusetts, which includes the affidavit, and then also the affirmative disclosure if the status changed. So adding a sub D to that, okay? With regards to paragraph 36, it gets modified to say that the objecting party has to articulate by Bates numbers, what are the confidential documents, unless you all, after you leave here, come to some other way you all want it. I'll look at it and just has to be by agreement of the parties, mutual agreement. If not, it's Bates stamp is the easiest way because that's how we do it in all the other things that I said. Okay, still got the 7 days, still got the 14 days, still the protective order. And then, of course, you're going to need to address the process of how these go before a special master first, because you all agreed that this is a discovery issue, correct? That goes to special master first. Is that correct? Does anyone need to be heard on that one? Everybody agrees it goes to special master first?
Yes, Your Honor.
Yeah, sure.
Okay, so, and then a report and recommendation to this court consistent with the CMO that I've not yet seen. The court, with regards to the objection of the state that was also stated that this is a hypothetical and not right for the court to issue a decision. The court does not agree with that because I find that it is ripe for decision because you all have even, well, A, it's not in the brief. So it's a brand new issue raised for the first time in the hearing, so can't address it that way. Even if I could, I'll say address it, and I still would deny that concept because it is ripe, because there is an actual issue out here. What is the proper process for the parties to handle confidential documents? That is presently before the court, and it is appropriate to do it before documents start getting produced, because that way the court can ensure that all of these issues get addressed in a timely manner and ensures that you don't have to worry about clawbacks. At least you're minimizing the issue of clawbacks. In fact, it's more appropriate to address it now than after some inadvertent disclosure, etc. The court in no way is taking any position on any other state or any other jurisdiction. When I use the term Commonwealth of Massachusetts, I'm just using it as an example because there was actual written language that was referred to by both parties and is actually in the record before this court. And so that's why I'm utilizing that language, but I also read it. So regardless if it was specifically in that order, I read it as well. Okay, I think I've now taken care of all of that. I've taken care of the fact that you all are, so it is so ordered. There, that one's done. 14 days, EDCR 7.21 to the DC 31 inbox, consistent with the administrative order. Does someone need more than 14 days? I think.
No, Your Honor, not from Meta's side.
Okay.
No, Your Honor.
Okay. So. Taking care of that, taking care of the processes, already gone through all your 16.1. The only thing I didn't give you on your 16.1 was your pretrial conference and calendar call date. But I told you that's going to be in the order because I need to evaluate whether we're going to do it standard with a standard pretrial conference, which is usually about a month out, and a standard calendar call, final pretrial conference, which is usually 2 weeks out if I need to do something different, or if I just put some caveat language, they give you the standard and say subject to the court needing something different at a status check to be held at a future date, which is more likely what I'm going to do. And then you all owe this court by Friday, the status conference, right? Dates that you want.
That's correct, Your Honor.
Okay. Anything else that anybody thinks is outstanding? You've got my full attention as you've had for most all of today. Anything else? If not.
No, Your Honor.
Okay.
Thank you, Your Honor.
One second, hold on. What's this? Oh, no, it's not. Okay. Okay. Then with that, have a very nice evening. Some of you I will see in less than 12 hours. No. More than 12 hours. Less than 24 hours. I don't know. I just live here.